Okay, this is part two of the hearing on August 19th, 2024, case number RP 221-20163, Honorable Judge Sandra Bean residing. Case number RP 221-20163. Cancer patient died. Yehuda Ferris of Chabad of the East Bay became his trustee. The beneficiaries are protesting the fact that they sold the property for $80,000 that was worth $1 million. They liquidated the $85,000 in cash, and they gave the beneficiaries, the poor elderly Jewish siblings, nothing. And then the daughters of this man, they never visited him once in the entire 6 years he was dying of cancer, and he left them exactly 25% each, but the opportunistic trustee, Yehuda Ferris, sold them the entire half in absolute 100% complete violation of the irrevocable trust for $80,000. They don't even live in the Bay Area. One's in LA, one's in Washington. The trustee's wife, Miriam Ferris, who inherited about $50 million in real estate and brags about it all the time, is going around telling everybody she's selling the house. And this attorney who's testifying wrote a threatening letter to the man's son, to the man's brother, saying, well, if you don't get out in the middle of the COVID pandemic in May of 2022, we're going to disinherit you and you're not going to get a dime. So he couldn't leave because there's nowhere to go, and it is a life-threatening situation with COVID in May of 2022, and so they carried out their threat, and this is the hearing about it. So he says, well, this petition so the brother of the cancer patient is interrogating the attorney who wrote the trust. And so the answer, he says, well, this petition to contest the trust I see as a court file stamp July 29th, which was 2 years after the 120 days. And then the attorney for the daughters, this guy Briar Horn, who's representing them in their illegal purchase of the property, no further questions, Your Honor. The judge says, all right, any questions within the scope of direct? So then the man's brother says, yes, go ahead. Okay, so the man's brother says, before I begin, I don't know if it's too late, but when you asked me if I objected to the notification, I was not aware that he was including a proof of service. If I could go back, I would like to object to the proof of service, but I don't recall that document. But I do have some questions on direct. Why don't you ask him questions, said the judge. Okay, bear with me. Give me a second. Cross-examination by the man's brother of the attorney who wrote the trust. Now, this attorney got $57,000 in attorney's fees. The brother and his two elderly sisters got $4,000 5 years ago. Okay, so the brother says, when you send out the notification, okay, you'll have to bear with me for a minute. Did you include a copy of the original trust when you gave it to Rabbi Yehuda Ferris? I don't think he's a rabbi. I mean, I don't know if he's a rabbi. I take it back. Yehuda Ferris. Did you include a copy of the original trust in the amended version that you sent out? So Yehuda, Will Rogers, well, I see from this proof of service that I have a handwritten notification reads that I served the following documents. First, it's the printed notification by trustee. Then that's my handwriting. It's the printed notification by trustee. And then that's my handwriting. It says with the copy of the trust, and I circled it. Not to interrupt you, said the brother, but was that the first or the second trust? That was the August 26th trust of 2019. So then the brother says, okay, all right, and if it's within the scope, I mean, Judge, Your Honor, you tell me, I'd like to bring to the court's attention then the judge says, so, mister, this is the time for you to ask questions. Yes. So he says to the attorney who wrote the trust, are you aware that in the original trust there's a statement? It says, you wrote this trust, Mr. Rogers. It says on page 2, it says Article 4, during the lifetime of the settlor, the trust may be revoked in whole or part by any instrument in writing signed by the settlor and attached to this instrument, or an instrument or a copy of this instrument and delivered to the settlor's successor trustees. The question is, did you do that? And the last thing it says is, on revocation of the trust, which you wrote, the trustee shall deliver to the settlor all or a designated portion of such. The court, so what's really important is that you ask one question at a time. During the lifetime of the settlor, okay, ask one question at a time. Okay, hold on, ladies and gentlemen. Okay, thank you. You You had asked one question, then you moved into another. Okay, I'm sorry. The judge. So ask your first question again. Did you include a copy of the first trust when you presented the second trust to the trustee? And then Horn, right, because he's fighting for the daughters who stole the property illegally. They shouldn't have bought it. They're not allowed to. He says, okay, so objection, Your Honor. I'm unclear what's being asked. I'm not sure what the first trust is. He knows very well what the first trust is. So the first trust is right here. Let me rule on the objections, okay? So the objection is sustained. That means you need to rephrase. Okay, thanks. This is a copy of the original trust that Will Rogers, and then so typically the judge says you refer to documents as exhibits instead of holding them up. That's why we all have these numbers, okay? Okay, so if you want to talk about something that's an exhibit, let's refer to the number. Okay, I don't know the number of this exhibit. It was, well, look it up. I think it's in the binder in front of you. Handwritten notification which reads, I served the okay, hold on. Man, I'm sorry, folks on YouTube. This is really a pain in the neck. Okay. I don't know if I have that. I've got to address the court about this. Do you have that handy? I could get through this for a long time. The court, hold on. Let's get off the record. The court, back on the record. Go ahead and ask your question. Okay. Mr. Rogers, on page 2 of the first trust dated March 14th, 2019, which you drafted, Article 4, it says, powers to amend or revoke. It says, and I quote, during the lifetime of the settlor, this trust may be revoked in whole or in part by an instrument in writing signed by the settlor and attached to the instrument or a copy of this instrument and delivered to the settlor's successor trustee on revocation. Okay, just stop there, said the judge. Did you do that? Asked the judge. The witness, not exactly, no. Lee was alive at the time. He had the power to revoke the March 19th trust. He revoked it by creating the August 26th trust, which he signed and gave to me. All right, let's ask your next question. It says, Section B, it says, hold on, YouTube world, be right with you. It says, during the lifetime of the settlor, the trust may be amended in whole and part by an instrument in writing signed by the settlor and delivered to the trustee. Did you do that? Did you deliver a copy of the original trust to the trustee? Again, it says during the lifetime of the settlor, this trust may be amended, which it was August 19th, is the amended trust, in whole or in part, in writing signed by the trustee and delivered to the successor trustee. So my question, Mr. Rogers, is, give me 1 second here. Objection, Your Honor. Did you or did you not? Hold on. We got an objection. I believe that the question was asked and answered, but there are 2 paragraphs. Excuse me, I'm sorry. The judge says the question for the court is whether it's within the scope of the direct. Are you asking? It's your turn. I'll put an objection on beyond the scope of direct. All right, sustained. Thank you, Your Honor. Okay, Mr. Ziprin, you don't need to ask about the first trust because we're talking about the second trust, the operative trust that was revoked. Could you elaborate briefly? No, I can't. Okay, ask your next question about the notice. Why? Bear with me. Okay, when did you sign that notice? Well, I have no, and so Roger says, well, I have no independent recollection, but the proof of service has a date of March 27th, and I signed it on that day. But isn't it true you don't remember the exact date that you signed it? That's correct. I don't remember the exact date. I'm going by what I have written here, which is consistent with my usual practice. I signed the proof of service on the day that I mailed the document, but I have no independent recollection of mailing this. I mail lots of things with proofs of service. Do you remember what mailbox you put it in or what method you were sending it? Did you drop it in the mailbox? Did an office, what is your typical? I would object. This is beyond the scope of direct, but also its relevance. He's already asked and answered. Sustained for relevance. Is there a description of the mailing from Petaluma? That's sufficient. Mr. Brother, this appears to be an adequate proof of service. Okay, let me see. Bear with me. I'm going to wrap it up. If you give me 1 second. Your Honor, can I address the lack of the first trust being given to the trustee when the second notice was created? You can do that in your argument. Okay, so give me a second here. What you want from Mr. Rogers are any facts? Facts? Facts. Okay, do you have any calendar records or billing records of the time you spent drafting that notice? Probably. Could you produce them? Relevance, objection, sustained. I have other questions, but they've got to wait. For example, did you do all that was required by the original trust to do the amendment? That's not here. That's not in this moment. Okay, no further questions at this time. Okay, any redirect? No. Mr. Rogers, one question. At the time that you were served the notification by a trustee, that's Exhibit 17, was it your understanding that the brother lived at the Grand Street, California? Yes, it is. And what did you base it on? My prior knowledge of Lee Ziprin, who was my client. I had been to Mr. Ziprin's house. I saw him there. It was the address that he would send me information from, so that's the one and only address that I have for him. All right, thank you. Can this witness be excused? Yes. Then thank you. You are excused. An argument? I would like to address the one case that was cited, Harustak. This is the attorney for the daughters who illegally obtained property in violation of the irrevocable trust, I believe is what it's called. And this is the only case that the brother who only got $4,000 in 5 years out of $1 million trust, when he was supposed to get part ownership of the property or a lien on the property with interest until paid in full. At this point, the three siblings combined $165,000 that he cited in the actual petition itself, and this is his response to the motion for, and then in his response to the motion for judgment on the pleadings. And so I believe that's the only case that's relevant. I know that he tried to say other cases. I was unable to find them. If we look at that case, it's about one thing. It's about notification by trustee that failed to include the statutory required language that actually warned the beneficiary of the 120-day deadline. And the court in that case found that if you don't even inform the beneficiary properly of the 120 deadline, then the deadline would not apply and the statute won't commence. That is irrelevant here because, as you can see from Exhibit 71, the required warning language is there. It's bold, it's large. He was never claimed that the language is not there or that he wasn't aware of the 120-day deadline. So I think that addresses really the only legal argument that he has made. And I would ask that this court find that his trust contest that was filed July 29th was years late and there's no excuse for its lateness, and that he's barred from bringing a claim that seeks to invalidate the trust. Your argument, cross. Your argument, did you? I'm not questioning, just my argument, right? You're just giving me your argument. He's finished as a witness. Okay, bear with me. I'm going to pick up where I left off. I was talking about the discovery rule and that the validity that the 120 days should run from the day of the discovery of the second trust because it was not attached to the first trust, which is the rule and which is the law and which is explicitly spelled out in the first trust, okay? So in their reply, opposing counsel assert that they were not misled, that I was not misled, that I did not assert reliance on the wrong info, and I waived it. The case of Harustek cited, held below, the notice was defective without any need of recipient to be misled or to have relied on the wrong size of the font notice. It says a trustee's notice of the right to contest an amendment to a trust did not comply with the probate code. 16061.7G, which requires such a notice to be printed in the reasonable equivalent of a 10-point bold-faced type contained in a separate paragraph. Although the notice was contained in a separate paragraph and was presented in 12 bold, the entire document was printed in the same 12 bold type. Okay, folks, hold on a minute. Okay, and the notice was not bounded or otherwise distinguished from the remaining text. Accordingly, the trustee's notice of the warning of statute of limitations for contesting a trust did not satisfy the reasonable equivalent of the statute, 16061.7G. The court, Mr. Margulies, can you just lower the microphone closer to your mouth a little bit so I can hear you better? Okay, thank you. Sure. So California courts have established that a trial court should grant, okay, now I'm going off, leave of amend if there's any reasonable possibility that the plaintiff can state a good cause for action to amend. So, Mr. Margulies, this is not a leave to amend issue. It's a jurisdictional issue. It's a statute of limitations, okay? Okay, so there's no reliance. They cite the San Diego case. It didn't follow the discovery rule. Bear with me. Oh, gosh, bear with me. It says here under Probate Code 16061 in 6.7, trustee's duty to serve notification of changes. I did not receive that content Damages. That statute sets a strict deadline that is not, okay, I'm sorry, I'm a little disorganized. Says in California, the late discovery rule applies to both tort and contract actions. It is particularly relevant in cases involving difficult to detect injuries or breach of fiduciary duty where the harm may not be immediately apparent. And this is cited in Royal Thrift and Loan Company versus Escrow, Inc., that is 123 California Appeals 4th District 24. Wind Dancer Production Group versus Walt Disney Pictures, 10 Cal Appeal 556. This rule is also applicable to specific statutory claims such as those involving financial abuse of an elder or dependent adult where the statute of limitations is 4 years from the date the plaintiff discovers or should have discovered the facts constituting the abuse. That is 15657.7 statute of limitations. This rule ensures that plaintiffs who are unaware of their right to sue due to no fault of their own are protected. Holger versus Community Development Commission, 1110 Cal App 4th 1288, Marino versus Sanchez, 106 Cal App 4th 1415. Okay, I would hope that this court would sustain the tentative ruling based on what I've said. I filed my claim within 120 days of discovering the second trust, and I want to bring to the court's attention that soon after my brother's death, when the trustee and Mr. Rogers and his wife, who was in the room here, came to my brother's house or had been living with him for a year, we turned over to him, this may be irrelevant, but they came to pick up $69,000 in cashier's checks that was found in a trash bag that almost was thrown it. Because my brother took all his money out of the bank a few weeks before he died. During that visit, which was just weeks after my brother died, Rogers and his wife and the trustee, I recall sitting in the kitchen, and there was large garbage bags, and everybody was going through papers and throwing things out and tossing things in the garbage and disrupting things and all kinds of letters and belongings of my brother. And I had just spent a full-time year living with him 5 years prior, shadowing him, and I thought it was a sacrilege. It was startling. It was upsetting, and I asked everyone to stop, and they did. After I got upset, and they were walking out. They had big bags of large documents in their hands, lots of documents. And I remember, I just want to bring that to the court's attention. And that is suspicious, and that is inappropriate. And I think they were trying to hide documents. And I believe that this tentative ruling is correct. And basically, there's one thing I wanted to say here, if you'll bear with me. Sometimes I forgot. Hold on, I'm very amateurish here. There's one thing about this case law that I'm citing. I just want to read it, just one sentence, if I can find it. I don't know how lawyers do all this. They're organized with all their papers, not me. I just had the stack of papers I was reading from. While I'm looking for this, I'd like to say that the proof of service document, I object to it because it looks extremely unfamiliar to me, and I do not recall it at all. Okay, I waited 4 years, and if you can bear with me, 24. I don't know if everybody's waiting for me. Here we go. Here is what I want to say. One sentence or maybe more. I said this on Friday and I want to repeat it. There's one paragraph that I'm looking for on this back page. It says where the facts are. Where the facts adequately allege breach of fiduciary duty of undue influence, the court will allow a date of discovery rule to be applied when strict adherence to the date of injury rule would result in unfairness to the plaintiff and would encourage wrongdoers to mislead their fiduciary to delay bringing suit. It is particularly appropriate when the defendant maintains custody and control of the plaintiff's property or interest in the petitioners, as petitioners did. The result of this is Parker and Evans did not become known. In fact, even around the time of her death, Charles Parker assured Irma Young that all 4 children would inherit her property. The court therefore ruled the actual fraud was not discovered by the estate until the middle of 2000, such that the cause of action accrued at that time. The Code of Civil Procedure, Section 3338D, was the applicable rule for analyzing the timelessness of this probate proceeding because delayed discovery was justifiably asserted and well supported based on the misrepresentations and concealments on the part of the objectors and roles they played and undertook in Young's life and financial affairs. And it says where incidents of undue influence are alleged, hold on, ladies and gentlemen. Following rules apply regarding the burden of proof where the relationship between the parties relationship between the parties is that of parent and child, and the parent relies on the child for advice. Okay. And business matters. A gift inter vivos, that is without consideration, and where the parent does not have the independent advice, is presumed to be fraudulent and to have made under undue influence. The burden of proof then shifts to the child to show that the transaction was free from fraud and undue influence and in all particulars fair. Put differently, this presumption must be rebutted by evidence that the act in question has its genesis in the mind of the parent and that it was not voted by complacement of any act of the child. The child's burden of proof is by a preponderance of the evidence. And okay, what I was looking for originally was, bear with me. As far as this case law that I'm citing, there are only one subsequent appeals court decision that contrasts. Questions the Haruth case. Then there are 130 subsequent court of appeals that cite its favorability. All right? You're welcome. Thank you, the judge said. Thank you. All right, so the court will rule on the motion of pleadings after I hear opening statements. We have some time here before we need to take a break. If you'd like to start. Oh, and Mr. Rogers is trying to cover up big crimes of himself and the multimillionaire real estate tycoon trustee. All right, good. This case can be seen through multiple lenses. Through one lens, perhaps the most obvious and clearest, is about greed. Mr. Margulies' brother was unhappy with what he was left. He wasn't left anything, $4,000. He wanted more, and the facts support this. Baloney. Never got anything. $4,000. Supposed to get $30,000 plus 10% interest. Now it's 5 years later. That's $48,000, and he got $4,000. And yet this double talker right here, he wanted more, and the facts support this interpretation. Viewed differently, perhaps Mr. Margulies believed injustice had been done, and that the earlier the March 19th trust, the revoked trust, is the trust that truly expresses his brother's wishes. However, he forgets two things. His natural heirs of his brother's estate, his daughters, but they're not supposed to get anything but 25%, and you sold them everything for 1/10 of its value, but the trust says after all payments have been made, the residual, but not only 25%. The entry in this case is that he could have received under the March trust was similar to the monetary gift left to him under the August trust. Complete 100% lie, okay? Not a shred of evidence to that effect. In other words, the 4.3% of Lee's home that he would have received under the March trust was worth about the same or perhaps less than the $30,000 he was to receive under the August trust. He never offered anybody 30 cents. This man is lying through his teeth, okay? All this litigation, several years later, fighting over two things of similar value and much less value than the tens of thousands incurred by the trust as a result of his litigation. This is the biggest swindler on the face of the earth. Mr. Margulies argues in various pleadings that his brother lacked testimony capacity at the time he signed the trust. However, there's no competent evidence to support such a claim. Yes, he was ill. He had cancer. Yeah, very ill. In a coma the entire last year of his life. Very convenient for these shysters to forget these things. But there's no causal connection between his cancer and the signing of the August trust. There's no connection. He was in a coma when he signed the trust. There's no connection. Man, I wonder if Bernie Madoff's attorneys said garbage like this. Lack of evidence never stopped his brother from making claims and filing petitions. There's a second view that the case can be seen from loyalty or misdirected loyalty. He was loyal to his brother, his elder brother, when he needed personal assistance during the last 6 years, when he was really suffering. His brother was his assistant. He was devoted. He needed a partial liver donor. He was first in line. Yeah, take my liver, but it wasn't a match, and I don't think anyone doubts that if Lee needed a piece of his heart, he would have given him a piece of his heart. But the problem arose when he expected that the daughters would have donated a portion of their livers, and they didn't. Of course not. They never even spoke to him. He was outraged, indignant, perhaps alarmed over his brother's fate. They weren't even able to be reached because they're hiding, okay? This resentment over this issue made Margulies' statements, his later statements in litigation, this is a long thing, about his two daughters are so full of spite. Instead of allowing the two daughters a space to process the loss of their father, he attacks them, blames them for the death of their father, blames them in really foul terms. In addition, he accuses the two daughters of undue influence in the creation of the August Trust. Of course, he wrote letters and said, don't leave the house to strangers, we might need a place to live someday. It was a scam. One daughter was telling him, well, if you change your trust, we'll come visit you. I'll return this topic in a moment. Another lens that this case can be seen is someone unable to act in their own best interest despite attempts to persuade him to act. There was never a offer of any money. Never. This guy's lying through his teeth. Not a letter, not a text message, not an email. He doesn't have any evidence of anybody ever accepting $30,000. He's just lying. Okay? Told that, number one, the trust contest was filed 2 years too late. Second, he could not remain living in his brother's house. It wasn't his. Efforts made to reason with him to no avail. Nothing could persuade him from his chosen path. And reaching out to help him. What hand? Nobody offered anybody a penny. They sent a threatening letter saying, get out or else you're going to lose your inheritance. But there was no offer. If the judge hauled him into court and said, I want every shred of evidence of all the, what offer did you make? Rogers couldn't say anything. Was he going to make up some story about a verbal offer? What kind of verbal offer? Did he call the man's sisters? No. Did he call either of the sisters? Did he make them offers? After all, they're supposed to get an equal share. They didn't get anything either. The case was not the only case which he was battling. He filed separate civil complaint against the trustee. Yeah.